Good morning, everyone, and welcome to the Epilepsy Foundation of Connecticut, our fall webinar series. Today's topic is on education law in Connecticut. All participants are currently in listen-only mode and will be for the remainder of the webinar. Please type any questions that you have in the questions section at the bottom of your webinar screen, and they will be answered at the end of the presentation. Or if you have something in the middle of the presentation that you'd really like for Larissa to touch on, go ahead and type your questions, and we can read those and have her answer them at that time as well. We can be a little informal here. Okay, so I would now like to introduce our speaker, Attorney Larissa B. Johnson. Attorney Johnson founded AdLauream, LLC in January of 2017 with the goal of helping children in Connecticut achieve their greatest potential in special education. She knows the importance of having an education advocate on your side to help you plan and prepare strategies and negotiate for your child. Attorney Johnson is dedicated to advocating for children and helping parents and schools implement the services and supports for each child's unique needs, so that they can pursue further education, careers, and live independent lives. So I would now like to welcome Attorney Johnson to start our webinar this morning. Thank you.
Thank you, Monica. Good morning, everyone. I'm really honored to be speaking with you today and on behalf of the Epilepsy Foundation of Connecticut. This morning, we're kind of just going to go over some really basic elements of eligibility because that's a great place to start. And in terms of, how do I get services for my child if my child needs them? And then we'll talk a little bit about self-advocacy strategies, and then we'll talk about what you need to know and when to ask for help. And by no means is this meant to be a totally comprehensive presentation of all special education law. It's an awful lot to try to get through in 45 minutes. But if you do have any questions, please feel free to type them into the chat box, and I'll try to get to them as soon as I can. So, all right. So, yeah, first we'll talk a little bit about the legal background. So the two main laws are federal laws that are going to play into special education are the IDEA 2004 and the Section 504 of the Rehabilitation Act. And both have qualifications for eligibility. The IDEA 2004 was enacted with the purpose of ensuring that all children with disabilities have a free, appropriate public education that emphasizes special education and related services designed to meet the unique needs and prepare students with for further education, employment, and independent living. And this is a law that's in place to protect children and families. This law is written for families and children. It's not a law that comes into play to protect schools as much, although there are caveats, and of course the regulations and so forth give guidance on how schools are supposed to participate and act, although often schools are looked at as more as being the authority on what students need educationally over a family, but at least we have a law that puts protections in place. Okay, so this is just really quickly the definitions of what it means to have a disability under this law. And I apologize because some of the language is what I would consider to be outdated, and I wouldn't choose to use some of these terms, but a child with a disability means a child with mental retardation, hearing impairments, including deafness, speech or language impairments, visual impairments, including blindness, serious emotional disturbance, referred to in this title as emotional disturbance, orthopedic impairments, autism, traumatic brain injury, or other health impairments or specific learning disabilities. And by reason thereof, needs special education-related services. Other health impairments can often include ADHD. Specific learning disabilities can often include dyslexia, dysgraphia, dyscalculia. Lots of different issues could come into play. So It's not as simple, though, as a child having a disability. Just because a child has a disability doesn't mean that they qualify for special education services. The disability must adversely affect the child's educational performance. So basically, if the child has a disability but does well in school and is learning well, participating well, they don't automatically qualify for special education services. There needs to be a demonstration that the disability affects the child's ability to learn or interferes with their schooling. One of the great things about this law, too, is that it places the burden on the school to locate children with disabilities. They're not supposed to turn a blind eye or ignore the fact that some of the children in their jurisdiction, in their locale, have disabilities. So part of the law includes this title called Child Find. So there's an onus placed on the district to find students with disabilities and make sure they're receiving, have them evaluated and make sure they're receiving appropriate services. So that's great because it kind of also gives you some room to work if there's a lot of issues going on with your child and they're not finding that your child, if they're not identifying your child as needing special services. So the next step would be, if there's a suspicion that a child has a disability that's affecting their education, the next step would be to have an initial evaluation done. This can be initiated by either the parent or the school, because sometimes, even though the duty's on the school to find the child, sometimes the school may not be as in tune to what's going on with the child as the parent, and the school may not share the same concerns. So depending on your situation, you may at some point find yourself approached by your district and where they tell you that they would like to perform an evaluation, or if you're feeling like your child is not being well served, you might want to initiate an evaluation. So either entity, either yourself or the school, have the right to request an evaluation. Basically, when a request is made for an evaluation, especially by the parent, the district has an obligation to consent within 60 days and do the evaluation. They technically can refuse, but then it tends to go to due process. So this is a really basic foundation of the law, and it's really, it really behooves them to do the evaluation. And if they're requesting the evaluation, the parent has to consent. The parent does not have to consent, but of course, if I were counseling a parent, I would suggest that they strongly consider consenting unless they have some really strong objections, in which case that would be a case-by-case basis. And then in addition to consenting for the evaluation, parents then also have to consent to the services. So it's not just about, okay, your child qualifies, now we're going to give them services and you don't have any say in that. You as the parent should have a say in that as well, what the services are and whether or not your child is going to participate. And so this just kind of goes over what I was just talking about, this slide. It is on the district's, it is part of the district's duty to locate the child and perform an evaluation, but sometimes they're not going to see what you're seeing as a parent, and it may be in your best interest or your child's best interest to request an evaluation at that time. Okay, so the best way to request an evaluation is to do it in writing. Always communicate with the school in writing, unless it's about a small day-to-day matter. But even then, I would recommend sending an email or sending a follow-up email. For an initial evaluation, you can make your written request in email form. I also suggest handwriting a note, like hand delivering a note. It doesn't have to be handwritten, but it could be typed up, and then deliver it directly to, I would say, definitely your school's principal, but then also consider delivering it to pupil services or student support services in your district. This is just it formalizes it. It keeps it personal because a lot of times this area of law differs from other types of law where we really look more at what the parent relationship is with the school, and the trend is to look at what parents are doing to stay active and engaged. And that's not always quite fair, but because there can be too much reading into parents' actions. But that said, the more cooperative and professional you can be with the school and show your involvement, the more that plays in your favor. So you want to document everything so that no one can say you didn't do this on time or you didn't do that. So you want to always have your requests in writing. Okay, and then of course, if something doesn't seem to be, playing out as you planned, like eligibility is denied or your request for an evaluation is denied, don't hesitate to reach out. In that case, I would say an attorney, but you may also consider reaching out to an advocate. You could get a second opinion on the evaluation, or you may have to go through due process depending on what's going on. So when you hit a roadblock like that, that's when you're going to want to get the help of a professional, because it can get very overwhelming very quickly and the procedures get pretty formal. So you want to make sure that you have someone who's knowledgeable working with you, because it's very difficult to go this road alone. So, especially for children who have epilepsy, epilepsy may or may not really deeply affect their learning. It definitely has an impact on their school day, and we have to be really thoughtful about what they need at school to have a successful school day, but they may not have any impairments that impact their learning. So you may have an evaluation and then they say, well, they don't qualify for special education. Well, they still may have a disability under Section 504 of the Rehabilitation Act, and then you want to pursue accommodations under 504. So we'll take a little bit of a closer look at 504. Because 504 adds a lot of protections for students, and actually 504 will cover students who have an IEP under IDEA as well, an independent individual education program plan. But 504 will give accommodations for students who have a disability as well. So to qualify for a 504 plan, basically a student has to have a physical or mental impairment which substantially limits one or more of the person's major life activities, and there's a record of such an impairment, and or the child is regarded as having such an impairment. And basically the major life activities include walking, seeing, hearing, speaking, breathing, learning, and working. It can also include thinking. So anything that, that's why ADHD often qualifies under 504, and a lot of times districts don't elevate it to the level of IDEA, but like ADHD falls under 504 a lot because it impacts how a student thinks. And then, of course, if you have epilepsy, there's going to be possible medical considerations and medications and so forth that's going to impact the child's day, that's going to require accommodations. So, it's definitely a great extra level of protection and accountability, although it does not have the same impact as IDEA. Okay, so let's talk a little bit about some of our advocacy strategies. One thing that's going to be really important for you as a parent is to keep really clear records and have a really organized file. Basically, you want to document everything and keep it organized, preferably chronologically. Keep all of your IEPs, keep all of your evaluations, progress reports, classroom report cards, keep scores from standardized tests, keep all of the communications with the school, especially via email, and all the communications from school. And you're going to want to document everything, as I've mentioned a few times, because that's how important it is. And that's going to be the way you tell the story about your child. And it's unfortunate that we have to think ahead and how we would prepare for something negative, but that's going to be your best protection for documenting kind of the story, because when something comes up, you don't want to be scrambling backwards and trying to figure out, well, they said this, I said that, and it's not documented anywhere. So even for daily happenings in the classroom, if something is overlooked or you have a conversation about your child's progress with a teacher, follow up with an email. You can send it directly to the teacher. You don't have to formalize every communication, but just follow up with an email. Dear Ms. So-and-so or Mr. So-and-so, thank you so much for taking the time to speak with me today about my child's progress. It would be, my understanding based on our conversation was that, we need my child to do this. You are going to work on that. I'm going to work on this. Thank you so much for your time. Have a great day. And, just kind of setting in that accountability, following up, making the documentation clear, and that'll help a lot in the long run. So if you're going to be heading to an IEP meeting, especially following a eligibility determination, there's definitely some things you're going to want to do to prepare. Number one would be create a parent's agenda. So as like any parent, you probably have a lot of concerns about what it is that they're going to talk about and whether or not they're going to cover the things that you want to talk about. So make sure you make it clear what you want to talk about, what your concerns are, and write down a few items as part of a parent's agenda. There may be a lot of things that you want to talk about, and that's totally understandable. Some of these IEPs are 20, 30, 40 pages long, so there's a lot to talk about. But having too many items on your agenda may be a little overwhelming. So you want to kind of keep it broadly organized and focus on up to about 5 major issues. Some of the things you might want to talk about are what the goals are, what the progress has been. Unless it's just getting started, you're not, but you want to talk about progress measurement. What is that going to talk about? Like, what's that going to look like? You can try to talk with them about methodology. You may be, because schools don't always like to talk about methodology because they say they have no obligation to follow a particular methodology or be held to it through the IEP. You can still talk about what accountability looks like. I don't know if I would use the word accountability right then and there, but I would definitely talk about, okay, so if my child needs reading assistance, what's the service being provided? How are we going to measure their success? How are we going to know when they're making progress? And talk about what the plan is, whether or not that, you can ask about methodology, but you want to kind of keep it broad and talk about how you're going to know when it looks good, like when the progress looks good. So, and you can either give your parents' agenda to the district prior to the IEP meeting, or you can bring it with you and present it at the beginning. It kind of depends. I would say it would depend for you on what your relationship is like so far. If you're on good terms and you're feeling good about your relationship with the school, I would definitely send it ahead of time. If you're a little bit more concerned that it may not bode well for you to have them in advance to prepare, you could bring it with you. But for the most part, I generally suggest that you want to communicate any major issues with the school that you want to talk about 3 to 5 days in advance so they have an opportunity to better prepare. And you may want to, like as we've talked about, put that in writing and let them know that you want to talk about it, and any information that you want to share with them. I can think of some examples, like if there's a particular program or method that you want them to consider, you would want to send them information about it ahead of time and ask that they review it. Because sometimes they're not going to be ready to talk about it at the meeting, and they may try to say, well, we didn't know, we didn't have a time, we didn't have a chance to look at this. And if you have sent it ahead of time, that's not so much of an excuse. I'm hoping that everyone has the opportunity to start off on a good foot with their PPT, and that's what we call them in Connecticut. The IEP meetings are called PPTs. It's the planning and placement team. And so you as a parent are a team member, and you're supposed to get a vote. Unfortunately, it's not literally a vote. It's very informal, but you're supposed to have a say. Unfortunately, typically when you go to one of these meetings, there's anywhere from 5 to 10 members of the school team present, and it's just you or you and a spouse or partner, and it can feel very overwhelming. But remember that you are a member of the team and that you do get a say in what's going on, and you should assert what your feelings are. It should be a collaborative process, but it doesn't always feel that way. However, I would encourage parents to try to stay as collaborative and positive as possible during the process, because that extra niceness can go a long way. If you feel like things are getting a little bit more adversarial, try to stay positive and then bring in somebody with you to help you, whether it be a friend who has experience working with the district, and or knows your child really well, or consult an education advocate or attorney. But you kind of want to give the school some time to work with you and be positive. So if you're going to an eligibility determination meeting, or if the meeting is following a new round of evaluations, ask for a copy of the evaluation before the meeting. You may want to make the request like 7 to 14 days ahead of time, and then request that you get the results back within 3 to 5 days ahead of time. You may get varying responses to this. My suggestion is that you kind of just keep with saying that in order for you to be a full functioning member of the team, you need the information ahead of time to review so that you can be prepared. And this will help you know what to expect, know what you're looking at, because so commonly what they would like to do at meetings is have each person who administered a part of the evaluation sit at the table and read through their evaluation. If you're already familiar with it, you're not having to think on the go. You're already kind of anticipating what they're going to say. And that can help you prepare to rebut some of their, usually it's not their concerns, it's usually them being not concerned. So if you kind of, are seeing where the scores are coming out, or maybe, they've done an OT eval, an occupational therapy eval, and that's not particularly relevant for your child, and there's not really a lot there, you will know that, and that shouldn't be an emphasis. And then conversely, if they've done a psychoeducational evaluation and there's a lot of concerns within that evaluation, you're going to know what they are ahead of time, so you're not caught off guard. So as I mentioned just earlier, you may want to consider bringing a partner or friend. Oftentimes people may bring their partner or their spouse. Sometimes, I definitely encourage both parents to be involved if they are able to. You typically always want to have at least one parent present. If they're scheduling a meeting for a day you can't be there, you should absolutely request that they reschedule it for when you can be there, because your participation is really essential. And then even in addition to you and your partner being there, you could ask a friend to be there, especially a parent of another student with special needs, or you could have an advocate there. And like, as I mentioned, if things are kind of getting a little hairy, you can also request to have an attorney there. Hopefully, though, things are still on good terms. And one of the suggestions that I have heard of that works well is to bring snacks and refreshments, because some of these meetings go on for quite some time. Teachers love to receive snacks because, they have long days too. They're human too. And it's helpful to bring a little refreshment, because it kind of, it kind of releases some of the tension. They look at you from a different perspective, and you're able to keep it more amicable. And then just along the lines of my suggestion to document everything, I highly, highly, highly recommend that every parent who has a child with special needs gets a digital recorder. You want to bring the digital recorder to every PPT meeting, because you just don't know what they're going to say or how it's going to go. And then the minutes in the IEP may not reflect what your understanding of it was, and it's better to have it recorded. It is very important, though, that if you bring a recorder and are recording, that at the outset you notify them that you're doing so. You pretty much have the right to do it. They're going to want to record as well, and they have the right to do it as well. And then if you don't tell them, A, it's not admissible in court, and B, you're going to destroy your relationship with them. Because if they find out that you've recorded them without permission, they're going to feel betrayed or violated, and that's not going to help you. So it's really important to record, because so often something happens in the meeting and you come out and you go like, I cannot believe they said that, or I can't, like they said they were going to do this and then now they're not doing it. It's not in the IEP. Well, you don't have any evidence that they said that or didn't say that. And if you had been recording, you would have it. So definitely invest in a recorder. The picture of the one I have there is the one that I actually have, and I think it's really great. And if you search on Amazon, you can find a bunch of them for, they're a little bit expensive. I'm sure you can find something cheaper. You could, of course, use your phone, but it's probably, I like the idea of having a separate recorder, especially a digital one, because like for instance with mine, I can just plug it into my computer and pull the file off. With the phone, you risk getting a phone call in the middle of it, stuff like that. Like it's not as clean. So, okay. So following the meeting, you want to make sure you review the IEP thoroughly. Take notes of anything that was a concern for you, and anything that you notice as an error, or that doesn't match up with what you thought. If there was any requests made, were they denied in writing? That's called prior written notice. And then, just look and see if the goals look appropriate. Just take a look at the whole thing. If you have concerns or disagree with the IEP, you want to write them up in a letter. You don't need to mention every single thing that's wrong with it. So often in the IEP documents, there's errors. And sometimes they're sloppy. But focus on the major educational items or services or accommodations, things that are going to actually impact your child's learning. And so you're going to want to write up your concerns, once again, try to stick to 3 to 5 major items or concerns, so that you're not picking the whole thing apart and writing a 10-page letter. You really want it to be like 1 to 2 pages maximum. And you're going to try to tell the story of, this is what I thought we talked about, this is what I received, I don't agree with this, this, or this. Can you please document my objections or concerns, attach this to the IEP. So you don't have to agree to the IEP, but they can move forward with it whether or not you agree, unless you try to file against them. But you can also attempt to re-meet with them and try to talk it through some more. But definitely document your concerns in a letter and send it to them, so that you're showing whoever's looking at the file in the future what your understanding of it was supposed to be and what you wanted to come out of it. Otherwise, the school gets to dominate the story, and we want to see your side of the story. And then progress monitoring becomes a really important part of making sure that the IEP is being implemented and that your child's having success. So you're going to want to be engaged with the progress monitoring reports, keep in touch with the school and ask how things are going, and try to find out whether some of the related services are actually happening, whether or not your child's actually receiving the accommodations they're supposed to, and stay engaged, because that's where you're going to be able to demonstrate, is the IEP being followed, and if so, is your child making progress and able to move on to the next level of learning. So just some other things to keep in mind, because I hear about these issues from time to time. Sometimes parents get called in the middle of the day to come pick up their child due to a disciplinary issue. Theoretically speaking, that's not supposed to happen. That's part of the school's duty, is to teach your child, and especially if the behavior is relating to their disability or one of their disabilities, they're supposed to be making accommodations to handle those issues. So if you're getting a call in the middle of the day, know that that can be a 504 violation. Now, I'm not suggesting that you pick up the phone and say, no, I'm not getting my child, that's a 504 violation. I mean, you can, but I know as a parent, you're going to want to go like, oh my gosh, my baby, I need to go get them. And what are these people doing with my baby? So, been there as a parent. So if you choose to pick them up, that's fine. Just document it. Once again, document that they called you, document whether you picked them up or not. You don't have to, because, given the situation, it may make more sense just to do it and pick them up and have that peace of mind. But document, document, document. And the same goes for field trips. Every once in a while, I hear about a student not being invited to attend a field trip, or a parent being required to come with the child for a field trip. Once again, it's the school's obligation to provide that experience for the child, just as they are every other child. So if you're getting that request or being denied the opportunity to participate, document, document, document. You can object if you feel strongly about it, if you feel more comfortable keeping your child home or attending the field trip with your child, that's fine. Just document it, that was a condition. It's really up to you as the parent, of course. But, if there are other issues further down the line, it'll be good to show that there was a history of this as an issue. Okay. So just a couple notes about advocating for your child with epilepsy. Epilepsy, of course, can affect children in different ways and at different times, and it may or may not impact their educational needs. So you're going to want to look at what depending on where you're heading in terms of whether the child needs an IEP or just 504 accommodations. You're going to want to look at designing a really unique plan based on your child's unique needs. Considerations you're going to want to include are what type of accommodations they need, and this will go in either a 504 plan or an IEP. Accommodations for homework, extra time on assigned tasks, tests or quizzes, assistive technology possibly, or if there are certain things that make it more likely for them to have seizures, talking about how to avoid situations that might result in one and what that would look like. And if your child needs to go to the doctor frequently, making sure there are accommodations for that and for missed class time, as well as, and this is going to be really important, instructions and identification for staff for the administration of medications, both in routine and emergency circumstances and extracurricular settings. Once again, if your child has a disability, they cannot be excluded from anything extra at school for that matter. It's not just about the day-to-day in the classroom, it's extracurricular as well. So just make sure that there's a really solid plan in place. Get to know that school nurse really well. If that's who you want to administer the medication, that's probably who they're going to insist will administer the medication. But what does that look like? What to do if there's a seizure, if somebody's having a seizure, or what your child needs. Those are going to be really important to make sure they're all spelled out. And you know your child best. You may want to get some additional, you may want to talk it through with your doctor as well, just to see if the doctor has any additional suggestions or, concerns for how your child participates in the school day. And then you can take that back to the team and let them know what you think your child needs. And as I mentioned before, the 504 plan is going to give your child those protections against discrimination as well. So either way, it's definitely something that needs to be spelled out, whether it's part of the IEP or part of a 504 plan. And of course, the foundation, like the Epilepsy Foundation of Connecticut, they have some great resources for you. And then also the General Foundation website has, and I have this link here at the bottom of the slide, to go and check out their advocacy guide. It's very long, which is fabulous because it's filled with all sorts of answers to your questions and suggestions. But I highly recommend you check it out and see what some of the suggestions are for advocating for your child in that as well. Okay, so a lot of times, suddenly things kind of take a turn for the worse and you don't really know what to do, or you feel like you're feeling overwhelmed. It's not necessarily even that something has gone terribly wrong, but it's just kind of getting away from you. You don't feel like you understand what's going on. You're not sure what the evaluations mean, or your child has a disciplinary issue and you're not sure what to do. I highly recommend that at that point you reach out to a professional, someone who's more familiar with working with schools and has familiarity with the law and procedure, or has really good knowledge of special education. So I just kind of went over briefly, like, what does an advocate do? They can look at your child's IEP or 504 plan and make recommendations. They can help you advocate for your child's eligibility. They can help you create a parent agenda. They can help you identify and request additional testing and evaluations. They can help you interpret and request more data regarding your child's progress, attend meetings with you and speak about the educational matters with the team, and help you know when it's time to contact an attorney. They're a great place to start. And I even kind of said, you know, especially if you're a younger parent with a young child and you've just found out that your child has a disability, you should reach out to an advocate from the outset. Make sure that you're getting the services that you need. You don't have to pay them, you know, not that you don't have to pay them, but you don't have to pay them hourly. You can set up an appointment for just a general review and ask them about those types of services, just so you kind of have a roadmap of where you're headed and where you're going and what to look for. Attorneys are a little bit different in that they can represent you both in legal and educational matters at PPTs and legal proceedings such as due process. You're going to want to reach out for an attorney when certain things are denied, or your requests aren't going well, or your child's really not making progress. So if you request an independent educational evaluation and it's denied, you should ask for an attorney at that time, or seek out an attorney at that time, because the school is supposed to file for due process. And certainly due process has become very complicated over the past few years, and it would be most helpful to you to have legal advice on how to proceed, and possibly representation. And then if your child's failing to make progress or is determined not to be eligible for services and advocacy isn't working, you should seek an attorney. If you're considering outplacement or enrolling your child in a private school, or if the school district is recommending outplacement, you should probably consult an attorney at that time. Once again, you don't have to sign up for full-on representation necessarily, but it would be good to get the lay of the land, legally speaking, and perhaps come up with a roadmap of how you should proceed. Disciplinary issues, I highly recommend, if your child is getting into serious disciplinary issues or repeated disciplinary issues, that you should reach out to an attorney, because it gets very complicated very quickly, and a lot of times schools may not be forthcoming with information or services that your child needs while they're suspended from school, or may try to expel your child illegally. So it's not as simple as going to a hearing for the parent necessarily, and you want to make sure that you have proper legal advice. So if your child gets suspended for kind of a substantial period of time, I would say it's really around 10 days, but maybe even 3 or more. You may want to just reach out to someone and just kind of find out what your legal rights are at that time. If you find that the school is not complying with the IEP or the law, you would want to consult an attorney. And then also when the school is discriminating against your child or other students are discriminating against your child. This would be kind of covered under bullying and discrimination under 504. So that's an excellent time to once again get a consultation and see where an attorney might be able to help or help you navigate the situation. So that pretty much wraps up my presentation for today. Here's my contact information. If we're not able to answer your question, or if you have a question after the fact, you can email me or give me a call, and I do free 15-minute phone consultations. But other than that, I'm happy to take questions if there are any now.
Okay, it looks like we do have one here.
Okay.
Okay, so the question is, you had mentioned making sure that you put everything in writing or you know, documenting communication with the school. The question is you know, is email okay, or would, you know, have to be an official letter, I think is the question, or is email?
Email is okay. Yeah, email is okay, especially for little follow-ups. If things are getting more serious, like you're requesting an independent education evaluation, or you think that the school's really out of compliance with something, you may want to consider hand delivering a typed letter. But email is generally okay, and it's certainly a fine place to start. You know, but yeah, email is fine because it records that you sent it, when you sent it, who you sent it to.
Any other questions? Okay, it looks like we do have one more question here.
Okay.
Okay, when a neuropsych is conducted by the school and suggests outplacement, is the school required to cover the cost of the outplacement?
If the school agrees with the outplacement and the school's recommending outplacement, then generally yes, they would be paying for the outplacement, and they should be providing transportation services. If the neuropsychologist, especially, if the neuropsychologist recommends outplacement and they don't agree, they're going to say that they, you know, and the parent wants to pursue outplacement, that's when, you know, the school is not going to want to pay for it, and the parent may want to move forward, in which case they should consider consulting an attorney to navigate that. The school is not 100% obligated to follow the recommendations, especially of an independent professional who's making an evaluation. They may say, well, these are the services that the child needs, and we can provide those here, instead of recommending outplacement. So it depends on the specific situation. But just because another professional says the child needs X, it doesn't mean that the school has to agree.
But if the school is agreeing or suggesting as well?
Yes, and they should have to provide the, they should be paying for it.
Yeah, and if it's the neuropsych that from the school.
Yeah.
Okay.
I think they could technically get away with disagreeing with it, even if they, you know, ordered it. But if they're agreeing and they're suggesting outplacement, then it's their responsibility to provide the outplacement.
Okay. Okay, so we have a few more here. If a school is reimbursing the parent for transportation, is there a state rate or is it negotiable?
I believe it's a bit negotiable, but they may typically default to the federal rate, which you can kind of Google federal. It's like the tax rate of reimbursement for mileage. You can Google that, and that'll give you the mileage amount, but it may be somewhat negotiable.
Okay. Okay. Are daily living skills considered something that the school should help out with? Example, getting dressed, brushing teeth, that sort of thing.
that definitely can be something they will help with. It's going to depend on what their opinion is of what they think they should be providing, and whether or not there seems to be a basis in any of the evaluations for that. But it's definitely something that the parent can request, and that would typically fall under occupational therapy services, based on what you're saying in the question. But they can have responsibility to help with daily living skills.
Okay. And would that depend on age as well, or not necessarily?
Not necessarily, no. I mean, there definitely tends to be an emphasis on daily living skills for transition services, but that typically has more to do with being ready for independent living. If you have a younger child that has a disability, and the disabilities, they're impacting their ability to do some of those things, and that may impact their ability to function in the classroom as well, then they can and should provide those services. It kind of is very case specific, though. I'd have to look at, get more information.
Okay. Okay, one more question here. If a child is placed in the hospital for a long-term, like 3 weeks or more stay, is the school required to provide assistance to help the child catch up academically?
And they already have an IEP, I would assume, in this scenario.
Yeah.
Let's see. I would want to look into this question a little bit further to confirm, but it definitely would be worth having a discussion with the PPT. Have a PPT to discuss it. They should be providing some services to make sure that the child does not fall too much farther behind, and it's definitely worth pursuing. And if this person would like to reach out to me directly, I'd be more than happy to talk with them about this.
Okay. Great. Do we have any further questions? If people have other areas perhaps that were not touched on today that they would like to hear further discussion on, or a future webinar on, please shoot me an email at monica@epilepsyct.com, and we can definitely consider, having Attorney Johnson, come back and touch on subjects that you're further interested in. So we know and understand that this is a very broad topic here, and this is just a general overview today. So we discussed, having her, Attorney Johnson, come back and do something else for us. So please let us know. And I really liked the pointers that you gave for the PPT meeting, such as bringing food and really working as a team. I imagine that must be difficult sometimes for parents because of the nature of what you're dealing with, and sometimes feel like they're enemies instead of someone that you're supposed to be working with. So I really like that part that you gave there. Let someone else come in and be the bulldog,
Right. That's my best suggestion on that. Just because especially for those of us with younger children, we have a long way to go with the district unless you decide to move. So it's best for you to keep your relationship congenial as much as you can, and seek further help if you really get into the thick of things. So thank you, Monica.
Yes, and thank you for taking the time today. And those of you who are on, please share that this webinar took place today. It has been recorded and will be put on our website at epilepsyct.com, where people can register to listen to a recording of this. So it'll be available by the end of today. It should be on our website. So we'll have that available for you. So thank you everyone for joining today, and thank you Attorney Johnson again for taking the time.
Thank you everyone, and if you do have a personal specific question, feel free to sign up for a consultation or give me a call, and we can go from there.
Thank you.
Thank you. Have a good day.